For argument next, in number 88-155, Texas versus Gregory Lee Johnson.
Hi, my name is Conrad, and welcome to SCOTUS Simplified. Today, we will be looking at the landmark Supreme Court case, Texas versus Johnson. The facts of the case. Gregory Lee Johnson burned an American flag outside the convention center where the 1984 Republican National Convention was being held in Dallas, Texas. Johnson was burning the flag in protest of Reagan policies at the time. Johnson was arrested under a Texas law that forbade the burning of a venerated object, such as the American flag. Johnson himself was and is a member of the National Communist Brigade, though at the time he was a member of the National Communist Youth Brigade. The protest that Johnson was a part of consisted of others from the Youth Brigade and was the size of roughly 100. They were shouting various chants such as, "Reagan Mondale, which will it be? Either one means World War III. Johnson acquired the flag from another member after it was ripped down from a flagpole. While the flag was stolen, local authorities decided to drop these charges because there was not substantial evidence to prove Johnson stole the flag himself. Johnson fought the case and attracted the attention of attorney William Kunstler. Kunstler had fought for many clients in the past, most famously for the Chicago 7, a group of 7 defendants who were accused of conspiracy to incite riots during the Democratic National Convention in Chicago in 1968. Kunstler fought for them, and the case gained national attention for Kunstler's unrelenting defense. The Chicago 7 were eventually released and cleared of all charges, after some appeals. The Supreme Court heard argument for this case on March 21, 1989, and made their decision on June 21, 1989. So, who are the players in this case? For Texas, Kathy Alice Drew. This is Miss Drew's first time up on stage. For Johnson, William Kunstler. This is Kunstler's third time on stage, the first two being Smith vs. Phillips and Ward vs. Rock Against Racism. He would also go on to fight in United States vs. Eichmann a year later. Something we should take note of before diving into this case is a previous case leading up to this one, specifically Spence vs. Washington. Spence vs. Washington established that anyone can display an American flag that has images or words superimposed over it. Now that we understand one of the cases leading into Texas vs. Johnson, we can begin looking at the arguments posed to the court. Miss Drew starts off by establishing what she will be intending to argue to the court.
One is the preservation of the flag as a symbol of nationhood and national unity. The second is the preservation of a breach of the peace.
Drew poses 2 main points to the Supreme Court. The first is that the flag is a symbol meant to be preserved, and the second is that the kind of behavior that Johnson participated in could cause riots. Justice Scalia comes down hard on her first argument.
Why did the defendant's actions here destroy the symbol? His actions would have been useless unless the flag was a very good symbol for what he intended to show contempt for. His action does not make it any less a symbol. I think not at all. I think when somebody does that to the flag becomes even more a symbol of the country.
Scalia argues that a person burns a flag because it's a symbol. Furthermore, when someone burns a flag, it becomes an even greater symbol. Drew disagrees, however.
We are suggesting that we have the right to preserve the physical integrity of the flag so that it may serve as a symbol, because its symbolic effect is diluted by certain flagrant public acts of flag desecration.
Well, in a sense.
That is really all Texas is suggesting with this, is that we have got to preserve the symbol by preserving the flag itself, because there really is no other way to do it. There is nothing.
Drew says that Texas has a right to protect the integrity of the symbolism of the flag by preventing acts of flag desecration, or in this instance, flag burning. The justices aren't satisfied by this argument and latch on to key points of the Texas law in question.
State interest now, but
Yes, sure.
I assume under this statute, of course, it's not just one flag, it's 51.
51 flags are all 50 state flags plus the national flag. I'm confused by your question. I apologize.
Well, this statute prohibits the desecration of a state flag as well,
Yes, it does.
of the Texas state flag.
Yes.
And I assume if we upheld the statute in every other state, it'd have the same right.
Yes, Your Honor.
So your category for one flag is now expanded to 51.
The Texas law protects its own state flag, so now you have to protect all state flags under this law. It doesn't stop here, though.
But it does say the state or national
Texas
flag.
prohibit the burning of copies of the Constitution?
Not to my knowledge, Your Honor.
There wouldn't be the same interest in the symbolism of that.
No, Your Honor, it would not be the same interest, I don't believe.
Why is that? I was going to ask about the state flower. You're not going to.
Flower.
If the law aims to protect symbols of the nation or of a state, then why doesn't everything receive that protection? The nation and states don't have the power to enforce these laws in a meaningful way.
Statute.
Well, I thought the court had held that it's firmly settled under the Constitution that the public expression of ideas may not be prohibited merely because the ideas are themselves offensive to some of their hearers.
That's correct.
And this statute seems to try to achieve exactly that.
Justice O'Connor ends off this series of arguments with the fact of the matter: this law limits a person's freedom of speech. There is another matter to attend to, though.
Again, the Texas legislature has made a judgment in this area that public desecration is likely to lead to violence, that it can lead to violence. And I believe that the Court of Criminal Appeals' suggestions in this regard are a bit too narrow. That if you have to show an actual breach of the peace, your purpose in a flag desecration statute is obviated.
In regard to inciting a riot, Drew makes a good point. If the breach of the peace happens, then the point of this law is pointless. Texas aims to stop a breach of the peace before it happens. We now move to Johnson's defense, led by Kunstler.
Now, I remember, Justice Scalia, in reading your dissent in Community for Creative Nonviolence, that you said essentially a law directed at the communicative nature of conduct must, like a law directed at speech itself, be justified by the substantial showing of need that the First Amendment requires. And of course,
Kunstler uses a very content-rich sentence here, or, in other words, a lot is said in a very short amount of time. What Kunstler is getting at is that if a law is directed at limiting speech, or something else under the First Amendment, the law must, without a doubt, show that it is necessary to limit that speech. A classic example of this idea is the scenario where someone yells, "Bomb!" in a crowded theater. While you have the right to free speech, that doesn't mean that you are free from the consequences of that speech, especially if others get hurt because of it.
flag. There are many national flags. I counted 17 national flags. Each department here in Washington has a flag. They're national flags, and the state of Texas would also include those as national flags, certainly the president's flag. So I think that the word national flag needs definition in itself.
Kunstler comes back to an earlier point made by the justices. Texas's law is vague. Where is the line drawn for flags if every flag and national flag is included? The following excerpt contains references to cases not covered in this video. However, the point of the argument is still made clear.
Die case. Do you remember that from?
I certainly do.
From New Hampshire, where we said New Hampshire can't require you to carry around on your license plate the expression "live free or die." But certainly New Hampshire could have presumably prohibited, New Hampshire couldn't compel you to make any affirmative statement on your license. They certainly could have prevented you from making some statements on your license plate.
No, but I think in Woolley, as I recall it, they painted out. They did an affirmative act and painted out the "live free or die" motto. Jehovah's Witnesses didn't believe in that, so they painted it out. They did an act, and then the question was, was that act violating some criminal code?
And then the court said, no, you can't prohibit that sort of thing. But the reasoning of the court was that you can't require someone to make an affirmation. To me, that's West Virginia versus Barnett. But if someone applies for a New Hampshire license plate that has a lot of foul language on it, very likely that limited thing can be proscribed.
I know that.
Rehnquist gets at the idea that a state has, in the past, limited what someone could put on their license plate. Could this same idea apply here? Rehnquist believes so. We have limited speech in the past. What stops us from protecting a symbol from harmful speech here? On June 21, 1989, the Supreme Court decided in a 5-4 vote in favor of Johnson. The summary available at oyez.com expresses the opinion of the court well. The court found that Johnson's actions fell into the category of expressive conduct and had a distinctively political nature. The fact that an audience takes offense to certain ideas or expressions, the court found, does not justify prohibitions of speech. So, what do you think? While it is legal to burn an American flag in your front yard as a form of free speech, should you? Drew makes good points throughout her arguments. At the same time, is it the place of the courts to limit your freedom of speech? Next time, we will look at a contemporary case, Espinoza versus Montana Department of Revenue, and what it could mean for the future of religious-based schools.